Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. We got some huge news developing today. It's Thursday as I'm recording this. Out of the Ninth Circuit, a place we normally don't get good news, but we've been getting a lot of good news lately, especially when the defendant is the state of California, because the state of California now, for the fourth time this year, has taken one on the chin. This time, it deals with California's restriction on open carry. And does this mean that possibly we're about to see a seismic shift in gun laws in California? Well, I wouldn't hold your breath. Let's talk about what this case really does. Let's talk about what the remedies really are. And let's talk about what is good and what's maybe not so good on it. Let's get you all up to speed. So today, let's talk about the huge ruling that favors California open carry. Okay, hey, before we get going too far down the road we're going down, anytime I get to do a video about California, I got to give a shout out to my first ever subscriber in the state of California. That, of course, is Philip P. Philip P. has, of course, been preaching the gospel of Washington gun law down in the People's Republic of California for quite some time and has brought many of you on board. Philip P., this video is for you. Okay, so the case we're talking about today is the case of Baird v. Bonta. What the hell is Baird v. Bonta? Well, that's a case that's been kicking around for 4 years. Now, that is a challenge to California Penal Code 25850 and 26350. These are two laws. California has some of the craziest gun controls, so follow me if you would here for a second. In California, it is against the law to open carry if you reside in a county that has 200,000 people or more, which, of course, as you can imagine, constitutes a large majority of California counties. So immediately, there is no open carry allowed in any of those counties. If your county happens to be under 200,000 people, well, you can open carry if you're given an open carry license, if you're given permission by the state, which, of course, the state of California never, ever gives that permission. There were two named plaintiffs in this case. They sued the state of California, claiming that those laws were unconstitutional. Now, there was a ruling several years ago already now on a preliminary injunction. The court there declined to enjoin enforcement of the law. So Baird and his co-plaintiff had asked that the court order California to stop enforcing that law until they could resolve the case on the merits. The court denied that motion, said there's nothing wrong with this law whatsoever. Now, this is what I want you to understand. What the court here, what the Ninth Circuit 3-judge panel has done here is they have said, hey, listen, we've took a look at your ruling as it relates to your denial of that motion for injunction. You missed it. You missed it badly. They're not saying necessarily that the ruling itself was wrong, although in many ways they are saying that. But what they are clearly saying is, hey, you didn't even apply the law correctly, because whoever the judge was down there basically applied this just simple one-part balancing test. I'm not even sure where that came from, but it was like, well, if I enjoin this law, then people may die, and so I can't enjoin the law. And that was really as simple as the analysis was. Or as the court put it in this case, after a hearing, the district court denied the instant preliminary injunction motion without analyzing whether appellants were likely to succeed on the merits of their claim or likely to suffer irreparable injury. They now appeal the district court's order, arguing that the district court abused its discretion by 1, conducting an incomplete preliminary injunction analysis, and 2, that was flawed even on its own terms because it consisted solely of a speculative or even impermissible public safety analysis of the effects of issuing a preliminary injunction. And so to put more in simple English terms, when we are asking for a preliminary injunction in general, it's a little more complicated, but in a nutshell, we have to show two things. Number one, that we are likely to prevail on the motions, and then number two, that we are going to suffer irreparable harm if the law is not enjoined. The court here did not engage in either of those analyses, but really this one-part balancing test, which was kind of created out of thin air. So what the court has said is no, we're going to send this case back down to the trial court level, and you are going to apply the law correctly, and you're going to issue a ruling as to whether this law should be enjoined or not when you apply the law correctly. Now, in the opinion, and we won't get too deep into it, otherwise we'll have way too long of a video here, but the court lays out a real roadmap that just about anybody who understands simple English can use that will ultimately lead the trial court to, in all likelihood, a much different decision. And this is where we begin to see the effects of Bruen, because it continues to percolate to this day. Because Bruen, once we firmly define the analysis of how we're going to judge the constitutionality of gun control legislation, what we've done is we've started taking a fresh look at a lot of cases. That's why United States v. Rahimi is a case in front of the United States Supreme Court this November, okay? And what the court here said is listen, what Bruen has done here is when we take a look at the first part of the analysis on a preliminary injunction, which is, are you likely to succeed on the merits? And then we apply the correct constitutional standards to what's being challenged here, that is the Bruen analysis. Well, it's a pretty inescapable conclusion at that point that the plaintiffs are in fact likely to prevail. The court pointed out the right to carry a handgun for defense outside the home can be regulated only in ways closely analogous to regulations widely in effect in 1791 or 1868. Now, that's an interesting ruling. There's a lot of debate about whether we can look at the late 1700s exclusively or we can look at the 1700s all the way up through the 1800s. In this case, the court appears to say that, hey, there's really just 2 years, okay? 1791, 1868. If you can't match up to a historical analog on one of those, you do not prevail. So ultimately, if you want to know what this ruling stands for, it's this. The district court abused its discretion when it skipped any analysis of the first and most important winter factor in this case. And winter is the case that's being cited here by the appellate court to say these are the factors that should have been used in assessing whether or not this injunction should have been granted. And so when I said that the court actually laid out a roadmap, so that this trial court, which clearly struggled with applying the law and the constitutional standards in case they need a little extra help, the court has stated, first, the district court's analysis of the first winter factor must include consideration of the question whether the conduct that California's general open carry ban regulates is covered by the text of the Second Amendment. If it is, California bears the burden to identify a well-established and representative historical analog to its open carry ban that was in force when the Second or 14th Amendment was ratified. And so what the court here is saying is listen, this one-part analysis about, but it's going to save lives if I let this law remain in effect, that was never part of the analysis. And if we go back to the old two-part analysis that the Bruen court clearly struck down, the analysis was still not even that simple, okay? There was at least a general analysis first as to whether or not it infringed upon the rights, and then if there was a determination that it had infringed upon the rights, then they would engage in this two-part balancing test. The court correctly pointed out, in short, as numerous courts have correctly observed in applying Bruen, California must identify a historical analog that curtails the right to peaceably carry handguns openly for self-defense to a comparable degree, with a comparable severity, and with comparable blanket enforcement to California's open carry ban. And the court does not want the trial court sitting on this thing. This thing has taken way too long and we are nowhere near resolution, so as the court has ordered. Second, the district court must complete this preliminary injunction review expeditiously. It has been more than 4 years since appellants first moved for a preliminary injunction and more than 14 months since Bruen was decided, because even a brief deprivation of a constitutional right causes irreparable injury. And then finally, the court pointed out that, listen, if in fact you find that there is a potential constitutional deprivation going on here, not only does that demonstrate in and of itself that you have a likelihood of succeeding on the merits, but it also demonstrates irreparable harm. The court clearly pointed to case law which stated, recognize that in cases involving a constitutional claim, a likelihood of success on the merits usually establishes irreparable harm and strongly tips the balance of equities and public interest in favor of granting a preliminary injunction. Okay, so does this mean everyone in California gets the open carry starting tomorrow? No, it does not. It means it's being remanded back down to the lower court. There will be more time. There will be more arguments. California will come up with more disingenuous arguments. Ultimately, if the judge applies the correct standards, though, the plaintiffs will prevail. What will happen at that point? California will crap its pants. They will appeal to a full panel of the Ninth Circuit. It will get caught up there. This issue is a long, long way from being resolved. However, California, there is a case out there right now that if it is eventually victorious, you will begin to resemble the United States of America more closely. Listen, you may have more questions about the case. The case, once again, is Baird v. Bonta. We're going to link up the ruling down below so you can geek out on it. Any more questions? You guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is also down there in the description box. In the meantime, let's all remember that part of being the lawful and responsible gunner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.